If you're just coming on, I'm going to stay with you. We're going to talk about the duty to consult. If you're talking to someone who's really new to the subject, how do you sort of outline sort of the key points in it? Is it regulatory and then all these sort of where it spins off from? How do you sort of outline it to somebody?
Yeah, so it is regulatory, but a lot of the direction does come from case law. But to back up just a little bit, it really is premised on the idea that Indigenous peoples in Canada have rights that are constitutionally protected. And you'll hear those referred to as Aboriginal and treaty rights, sometimes as Section 35 rights. And what that means is Canada has a treaty relationship with Indigenous peoples that's premised on sharing the lands and resources. And so the rights that Indigenous peoples have in this country are the rights to subsist off of the lands, water, and environment. And so any project that happens in the country that can impact lands, water, environment, air, likely triggers a duty to consult. And that duty to consult can be variable, bigger, smaller, depending on the size and scope of a particular project. But it typically plays out in the regulatory process because the regulatory process is designed already to assess the size and scope of project impacts, as well as provide a decision by a regulator on whether or not that project can proceed. So the trigger for the duty to consult comes from that potential to impact those unique rights, but it is typically woven into the regulatory process. So that's why we see it come up time and time again in natural resource development projects. We hear about it when new environmental legislation is passed.
Okay, can we do a little bit of distinction between regulations are always changing and getting updated. That's part of the reason we're doing the show today. And then there's the constitutional side. So sort of what you're saying is there's kind of two separate streams that you have to understand. Is that right?
Somewhat. So if you think of the constitutional piece as really broad, so what's in the Constitution just says the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. So they exist, they're protected. The Constitution also says who the Aboriginal peoples of Canada are, so the First Nations, Métis, and Inuit people, but that's really broad. And so how it's kind of made it from being in the Constitution to being in regulations, which, as you say, change all the time, is Indigenous peoples have challenged government decisions for the last many, many years, saying that those decisions aren't upholding the protection of their rights. And so once the courts make a decision, then it sort of comes down to government to enact and take the direction of the courts and move it into law, move it into legislation.
Right. So where in the regulation side, where are sort of some of these trends, changes, sort of some standout points that we should cover here when we're talking about duty to consult?
Yeah, so you'll see as, when different jurisdictions, either federal or provincial jurisdictions, are renewing environmental legislation or impact assessment legislation, they're taking direction from the courts, and they're sort of trying to keep pace with those court decisions. Mm-hmm. I would say the court decisions are typically ahead of the legislation and regulations because they're happening all the time. But an interesting place to look is the new Impact Assessment Act, which is Canada's, the federal government's new legislation that replaced the Canadian Environmental Assessment Act that was in place since 2012. So now we have the Impact Assessment Act, and it specifically asks for project proponents to assess what the impacts are on Indigenous rights from their project activities. And that's something that's replaced the old legislation, which was more about traditional land and resource use. So they've evolved their understanding and what they're asking proponents to do in their regulations.
So what about, in all of these things, and which is obviously where you come into play for these companies, there's benefits and there's challenges, and it's always going to sort of be one or the other. Can you sort of outline those and unpack them for us a little bit?
Yeah, I think sometimes where we see project proponents have challenges is understanding and keeping pace with some of the changes in the expectations. And so, like I said, the courts are often ahead of where sometimes legislation and regulations are, depending on the jurisdiction. And so there are occasions where Indigenous peoples, Indigenous groups involved in a duty to consult process will have expectations that are perhaps different than what a project proponent might think is required of them. So I would always advise proponents to look to recent court decisions. Sometimes there's a requirement to go above and beyond what's in the legislation. That might be the bare minimum. You might need to do more. The duty to consult is held by the Crown, by the government. So if let's say an Indigenous nation does challenge the approval of a project, they're challenging the government decision. But at the end of the day, it's the proponent's project that is either delayed or at risk. And so it is in the interest of proponents to build strong relationships, engage early, engage often, sometimes do more than what they're being asked to do by the government.
When you see success coming from business, is that from a lot of the shows that I've done, it seems to be there's the major key is engage early. Have the conversation before you do your press releases and say what the plan is. And then so this Indigenous group is, they're reading about it in the news, and then you show up the next day to talk about it after you've already told the public what you're doing. I mean, in any negotiation, that's usually a terrible strategy. So that seems to be, that must be a major thing that you're trying to communicate to people to do it before you start talking publicly.
Absolutely. I would agree with that. And interestingly, the new federal legislation, the new Impact Assessment Act, actually has built in a pre-disclosure engagement phase into their major project approvals. So there, if you trigger federal approvals, which only certain projects will, you'll be required to do it as part of due process for that type of project. So it is good practice, and it absolutely is something that we would always recommend. I think the other important piece is also to look at the Indigenous nations that are potentially affected by projects as potential partners in those projects.
Yep.
So we're seeing a lot of nations that want to invest in projects and want to be part of the benefits that are coming out of those projects.
You know, you kind of made me think of something that it's sort of, and sometimes it's a personal area. You sort of go to the negative side of legislation and sort of the challenges of it. But I guess also they're also putting into legislation, like you say, that sort of pre-process that the companies should do. When they start to see that works, they're also putting that into legislation and into the regulatory side of things, so that companies actually have a better blueprint forward, because they might not be purposely doing something wrong in the process, but if it's actually legislated in, now they know the steps that they can follow. I guess that's the upside that there is as well, right?
Yeah, I mean, proponents like certainty, right? Mm-hmm. Certainty in process, and doing some of these things does, maybe doesn't have, you'll never have a certain outcome, but it can build some more certainty in terms of what that process and what those timelines might look like.
Germaine, would we be able to, do you have some sort of examples to sort of walk us through or sort of showcase an example of this kind of coming together in sort of a real world scenario that we could look at?
Yeah, I mean, I think there's numerous examples currently, and it would probably almost be challenging to find a major resource development project right now that wasn't an example of this right. In some fashion, to be honest. All major projects have an Indigenous consultation requirement. So there isn't one that doesn't. Some you'll hear more about. Often there's a lot of discourse or things make it in the news, and maybe everyone doesn't understand the context around it. So you'll hear over the last couple of years a lot around Trans Mountain, Coastal GasLink. So there's a lot of major pipeline projects that this issue comes up. Recently, we've been watching developments in Alberta around mining. Yeah. So there have been some recent decisions around coal mining in the province of Alberta, and particularly ones that are do have federal involvement. And so Grassy Mountain's one that people may have heard of because it was not approved, which doesn't happen very often. I mean, most of the projects that do make it all the way through the regulatory process are typically approved, not always, but they often do end up in project approval. So the Grassy Mountain project wasn't approved, and it wasn't approved. One of the deciding factors was that the impact to Indigenous rights was too great. So that's a thing that you don't see all that often, and did happen recently. And interestingly enough, that project did have signed impact benefit agreements with some of the First Nations that were potentially affected by it. Not all, but some of them. And so it's become a bit of a divisive project whereby there are First Nations that support it, and there are First Nations that don't support it. And the federal government did reject that project.
So what is the process, though? I kind of want to get I don't know how familiar firsthand you are with the project, but how long did that project take before of trying to get it through, was it automatically triggered up towards the federal? I don't quite understand the whole setup. Does that, when they say we want that project, just the scope of it and the scale, does it automatically become federal? Could you just walk us through the process?
Sure. So even under the old federal legislation, which was kind of shorthand CIA 2012 or the Canadian Environmental Assessment Act, and now the Impact Assessment Act, there have always been federal triggers, let's call them, built into that process. So if projects kind of trigger certain things, they can go into a federal process. And some of those examples might be just projects of a certain size, so emissions that are of a certain scale, things that cross provincial borders, things that cross national borders, things that have the potential to affect areas of federal jurisdiction, so on federal lands, impacting of navigable waters. So those types of things where the feds have jurisdiction over. If a project potentially impacts those things, then there are some federal triggers. So some of these mining projects, or you used to see it in the oil sands when there were really large open pit oil sands mining, they'll have federal triggers because of the size and scope of the project.
So where does MNP come in? I mean, obviously you're being featured on the show, and it's a pretty shameless plug, but that's okay, because I'm legitimately asking the setup of where MNP. I mean, you're a major player in your industry, so I want to understand. For people listening, at what point is MNP? What are you offering, and at what point should companies be engaging with you?
Yeah. So interestingly, I mean, I think the public perception of MNP is typically an accounting firm, which is absolutely something that MNP does. But we also do consulting work, and that's where Ed and I sit and play in the MNP world, is in our consulting services. And so we provide those services. In my particular field, we work for either Indigenous governments, public governments, or resource development proponents. Anyone who's involved in the duty to consult process. We have to be careful that we're only working for one of those parties in the duty to consult process, obviously, or we're in conflict. But essentially, the services we provide are, advising clients on how to manage their risk, how to run a good engagement process, how to assess impacts to Indigenous rights from a project.
So how does it work? A lot of time they would have their own people that are doing some of what you're doing as well. So are you sort of a third party that sort of, the idea is that you're coming in to be impartial, to sort of give them a clear path forward? Because, or how is that working? Or are you a lot of times filling in a gap that they do not have at their company?
So we'd be a third party. Occasionally we do fill a gap that a client may not have internally, depending on their existing capacity. We don't really play a mediator role. We would work for a specific client, because at the end of the day, most of these projects do go to hearing. And so we're sort of representing or supporting the client that we work for. So we don't play like a facilitation or a mediation role. Right. If that makes sense.
Yeah, no, it does. And my next question is, can I be a fly on the wall to some of that consultation?
So some of it is done obviously sort of bilaterally between kind of the Indigenous group and the company.
Yeah.
But interestingly, some where it does play out in the public sphere is when things go to hearing. And a lot of projects do go to hearing. So a lot of the projects that are under the Canadian Energy Regulator do have a hearing process built in, and
Yeah.
those hearing processes are available. You can tune in and listen when one is happening. A lot of pipeline projects are regulated by the Canadian Energy Regulator, so you can listen to those transmission projects as well. So that's kind of where you can sort of listen to the evidence that's being put forward by a whole bunch of different parties who have an interest in these projects.
I was wondering, when you're saying about that, when it is going to a hearing, is that because there is this might be a bit of a dumb question, but is it because there is a conflict, or because they just want it to be resolved through that system? Does it ever just go, we're not really sure how this should go, so we're going to, or is it always because of based on a like a clear conflict of two opposing positions?
It depends. So depending on the jurisdiction and the process that's laid out. So some processes have a hearing built into them as part of due process. So they're going to have a hearing. There will be people who are interveners on the project and will come to say, we support this, we don't support this, we have concerns about this. And it's just a part of their process. But in other cases, sometimes a hearing can be triggered because of conflict. Right. So you can start a process where there's, documents are going to be reviewed, they're going to be put on the record. But if it becomes quite contentious, the regulator may choose to put it to hearing, or they may get asked to go to hearing by a number of interveners and respond to that and say, okay, we'll have a hearing to put this before a panel.
But if we hear a hearing, we don't need to not just automatically assume that, oh, this is a conflict, that this is all negative, that it could just be that that's the process that's most beneficial to it. Absolutely.
And it gives not just Indigenous groups, but anyone who is potentially directly affected by projects, the ability to have a say to the panel. And like I said, an intervener doesn't even necessarily mean it's in conflict. You can have interveners who are intervening on behalf of a project.